The biological substance sample will be collected pursuant to Colorado law, and it will be destroyed, and the results of the testing will be expunged from the federal combined DNA index system and any state index system pursuant to Colorado law. If this case is completed and qualifies to be sealed or basically expunged, removed from your record. All of that is to say, for right now, Ms. Boyd, I don't find that I have the authority to grant what you're requesting. I understand the reference to the competency statute as well as to 1623-103. I agree that when Mr. Boyd goes to Colorado Springs Police Department, they need to be compliant with what this says. So they're supposed to determine whether or not there already is in existence a substance sample. And if there is an existence of such a sample, then Mr. Wood should not have to give another one. But it's upon the agency to make that determination, not me, okay? So that is to say, I'm not gonna remove that requirement from the fingerprint order. Do I have to issue a new one?
Yes, because when they went
Past 14 days.
right.
Okay. All right, so we'll issue a new one then, and then we'll just see what happens when Mr. Wood goes.
Okay.
So I have one question.
Yes.
If you can't do the stopping the biological because he's currently under incompetency request, do that mean we go and give the sample even though we haven't gotten the confirmation that they've already had it or not? Because isn't it your job, the police department's job, to know if they took a sample of him or not?
It's their job to be able to search the system that potentially would have that information and determine whether or not it already exists. If it already exists, they are not supposed to take a new sample.
In other words, I guess, because I've never attended one of these or gone with a client to do one of these fingerprint orders. I guess my understanding would be that when Mr. Ward arrives and tells them I have an order, that they should be looking up in the system before they actually put something in his mouth.
That's what this statute says to me. That's how I interpret it. Obviously, I'm not allowed to give legal advice, but that's my interpretation of the statute.
Because I think our concern is that if he is to show up and they kind of are just open your mouth and they don't tell him or say, hey, we looked and we don't see one. Obviously, I get what the court is saying. It's on them to do it, but I don't know what remedy or what we can even do ahead of time to avoid that.
And I will have to leave that up to you in terms of what kind of legal advice you give.
Okay.
But I don't feel like that's a question that I can answer.
I understand, I guess.
What I can say is if Mr. Ward comes back and hasn't done the biological sample part, I'm not going to put him in jail for, does that make sense?
Yes, and honestly, at this